Good day, everyone. The purpose of this discussion is basically arising from certain questions we had from our Sanlam private wealth client base, in particular about the change in legislation or the draft legislation that is going to be introduced on 1 March 2021, particularly in relation to the immigration requirements or how that will affect people's retirement annuity funds on immigration or immigration thereafter. It is important to remember that this is still in bill form and it may change, but the takeaway from this is that I think there has been too much said about the draft legislation on the basis that it has been ill-conceived or there were some hidden motives with the legislation, which I don't think is true. First of all, there is actually no such thing as financial immigration. It doesn't exist. There are basically two concepts, and they are cessation of tax residence and formal immigration from an exchange control perspective. These are total separate concepts. On the one hand, you basically take certain actions to cease to be a South African tax resident, and on the other hand, you take certain administrative actions through the South African Reserve Bank to cease to be a South African exchange control resident. The latter is an administrative process. Just to explain it a little bit more in detail, one can cease to be a tax resident without formalizing a person's immigration, and the other side is also true. You can also cease to be a South African exchange control resident without cessation of tax residence. These two are separate concepts, and you don't necessarily automatically cease to be a tax resident when you cease to be an exchange control resident. In the latest budget, in February 2020, certain announcements were made that the concept of immigration will be phased out. Now, immigration is quite relevant for people who want to get access to their retirement funds. As everybody knows, you can only access a retirement fund before death or incapacity after the age of 55. The current legislation, however, stipulates that you can access this retirement annuity fund once you have formalized your immigration through the South African Reserve Bank. For people who are younger than 55, they can therefore, once they have formalized their immigration, cash in their retirement annuity fund and actually, after taxation has been applied, exit those funds from South Africa as part of their immigration process. The newest legislation basically changed the rule, and insofar as the trigger for cashing in a retirement annuity will no longer be your immigration, but it will rather be whether you have completed a full 3 years as being a non-tax resident of South Africa. And this is very much in line with the budget, because the 2020 budget basically mentioned that immigration is not automatically a factor that dictate whether you cease to be a tax resident or not. The ordinary resident rule still applies. So therefore, under the new legislation, you will then only be able to access your retirement annuity once you have been non-resident for the 3-year period. Now, this is not draconian. This is something that is in line with typically anti-avoidance provisions. So if you look at Section 9C, if a person holds a share for longer than 3 years, that share is automatically deemed to be capital. In other words, you can't see it as income or a trading asset, and therefore you can only be subject to capital gain. So 3 years is a general rule that basically says that's a long enough period for people not to be falling foul of anti-avoidance provisions. The current exchange control regulations basically has got the same rule. So if you emigrate and you can actually not return to South Africa within a 5-year period as a result, because you will then, as a result, be regarded as a failed immigrant, and SARB can force you to bring those assets back. So the 3-year rule is now more tax-driven than immigration-driven, and all this articles in the press that the government is now holding on to your to your retirement annuity funds for a period of 3 years, and they've given you 7 months to do the process before the new legislation comes in, is, in my view, a little bit disingenuous. It's not the intention of the legislation. It is really to make the trigger rather a tax trigger and not an exchange control trigger. For example, if people are living abroad already for a long time and they have ceased to be tax resident, they actually don't need to do their formalize their immigration. They can actually then get access to their retirement annuities even without immigrating for exchange control purposes. So there's a definite plus in the legislation for those individuals who have been non-resident for 3 years as at 1 March 2020, because essentially they will be able to access the retirement annuities immediately. The draft legislation also will in future apply to preservation funds, especially for those individuals who already had their one withdrawal from a preservation fund, because essentially if you have before your retirement date used your one withdrawal, that preservation fund is also locked in until normal retirement age. So the added bonus in the new legislation is that for people who have got preservation funds, they will also be able to access that, not on immigration, because that was never the case on immigration. It is actually an added benefit in the new legislation that preservation funds will also now be able to be cashed in, even if you had your one-off withdrawal. Now, it's important to remember that pension funds and provident funds in the normal sense is not effective, because any person who resigns from his job can basically cash in that pension or provident fund as a resignation benefit, pay the tax, and that person doesn't have to emigrate to actually take the funds off, because he can utilize these foreign investment allowances to actually externalize that funds. If it's large amounts, then it can be done over a period of 1 or 2 or 3 years. So in my view, the new legislation is actually a benefit rather than a negative, and I'm just hoping to place this a little bit more into perspective. Another question we get is basically when people move from one jurisdiction to another, is whether I can move my pension or my provident fund to that jurisdiction. The answer is unfortunately very short: no, you cannot. South Africa doesn't have pension transportability. That means that you cannot actually move your pension from one jurisdiction or from your current South African employer to a new employer in Australia, for example. Now, this is a common occurrence in the UK, in Australia, and all those types of many of those countries where you can actually move your pension fund, but unfortunately in South Africa that is not available yet. Only way to get access to your pension when you leave is basically, as we discussed, in terms of the new bill, being out of the country for more than 3 years, particularly related to retirement annuities and provident funds where your one withdrawal has already been utilized. For pensions and provident funds, the normal rules apply. You can basically resign from those funds, pay the tax, and exit those funds as part of your immigration, your foreign investment allowance, or even on immigration if the resignation is done prior to that. As far as living annuities are concerned, that's one of the things they didn't actually tackle, and we were hoping that they would. Living annuities, you cannot access. The only way you can get hold of that, even if you've been a non-resident for tax purposes, or even if you emigrated, is to actually enhance the payment of the annuity income. At the moment, the current limits are up to a maximum of 17.5%. So the advice we have to clients is to expedite the payment by drawing down maximum on that. Yes, you will, of course, pay South African income tax subject to the double taxation treaty networks. And then you can also externalize those funds in terms of your foreign investment allowances, or if a person has immigrated as under the current rules, then then that can be taken out via a direct or via his Block Rand account. It is important to understand that in the latest budget 2020, the Finance Minister also indicated that they are moving away from an immigration basis of protecting the tax base, or a South African Reserve Bank basis protecting the tax base, and that the protection of the tax base should rather be on the SARS and side, and having sufficient legislation and a sufficient risk basis to actually tackle all foreign evasion and avoidance and these type of things. And one of the tools that they have in their pocket is the common reporting standards, which have been with us for a few years now. In terms of CRS, any banking institution basically now has to report to a central database where SARS have access to particulars of any clients or any bank account holders, etc., etc. And this is really the reason why immigration is probably no longer a requirement to control the erosion of the tax base, but SARS will have sufficient mechanisms and risk approach bases in place to actually capture the information. And in the long and short, there's actually no place to hide anymore. So that is really, in my view, the main driver from why immigration is being phased out, because SARS will be able to actually control the tax base and protect the tax base, especially from a base erosion and profit shifting perspective, as CRS basically gives them this very powerful tool. And lastly, although this has always been quite a complex area of expertise, the new legislation has actually made it a little bit worse. So for a person who wants to cease to be a tax resident, that person must look at his personal set of circumstances. There is no one-fit-all scenario. The ordinary resident test is basically specifically applicable to every person's particular set of circumstances, hence why they call it a subjective test. For immigration purposes, this is the million-dollar question. How it will actually pan out in terms of the new draft legislation is an open question, and it makes things a little bit more complex. And I would suggest, given all this various complexities, that before a person actually take the jump to leave South Africa, or thinks he leaves South Africa, to take expert advice on this topic, to make sure that if he left South Africa in 5 years' time, SARS may not come back and say, well, actually, you didn't really leave, and they may still assess you in South Africa as a tax resident, although you have ceased, or you thought you ceased to be a tax resident. So immigration, in my view, is probably good that it is phased out. A more tax-driven approach is probably more in line with international standards, and I would, given the current set of legislation, probably think that it will be implemented in very much of the current form. Thank you very much.